All right, let's go for it. Good afternoon and welcome everyone. Thank you for joining us, and good evening and welcome to those 1Ls who'll be watching this as a recording later at our watch party. My name's Warren Bloom. I'm the Vice President of Events for the Texas Federalist Society. I'm very excited to introduce our speakers for this afternoon's event, Concealed Carry and the Court, previewing New York State Rifle and Pistol Association versus Bruen. But first, to those of you who are not yet members of the Texas Federalist Society, please go to our website, texasfedsoc.org, and join. Now for introduction. Professor Joseph Blocher of Duke Law serves as co-director of the Duke Center for Firearms Law, the author of many articles on gun regulation, including one this year in the Texas Law Review. Professor Blocher is also co-author of the book, The Positive Second Amendment, Rights, Regulations, and the Future of Heller. He's also a co-editor of the forthcoming book, New Histories of Gun Rights and Regulation, Essays on the Place of Guns in American Law and Society. Before joining the Duke faculty, Professor Blocher clerked for 2 federal courts of appeals judges and worked as an associate at O'Melveny and Myers, where he helped represent the District of Columbia in Heller. We're also pleased to have with us Dr. Stephen Halbrook. Dr. Stephen Halbrook is a senior fellow at the Independent Institute and a veteran attorney with particular expertise in constitutional issues involving federalism, the Second Amendment, and other Bill of Rights guarantees. He's argued and won 3 cases before the US Supreme Court, and he's written many books and articles about gun control. In Heller, he filed an amicus brief in support of Heller on behalf of the majorities of both houses of Congress. In McDonald's versus City of Chicago, he filed an amicus brief in support of McDonald's on behalf of the NRA. And in Bruen, the case we'll be discussing today, Dr. Halbrook filed an amicus brief pro bono in support of petitioners on behalf of the National African American Gun Association. Dr. Halbrook's most recent book, The Right to Bear Arms, A Constitutional Right of the People or a Privilege of the Ruling Class, was released in May. Now I'll turn it over to Professor Blocher to tell us about the upcoming Supreme Court case and analyze it in light of Heller and what's been happening in the lower courts since that decision. After some back and forth between them, I'll moderate a Q&A session. So please submit questions that you'd like me to ask our guests. Gentlemen, thank you very, very much for joining us. Professor Blocher, the floor is yours.
Thank you very much, Warren, for that incredibly generous introduction. And thanks in advance to all of you for asking your questions. We're really looking forward to a lot of back and forth here, so please do drop them into the Q&A box there. It is really a pleasure and an honor to be here with all of you. It's a special honor to be having this discussion with Stephen Halbrook, who is, I just have to emphasize what Warren just said there, a towering figure in Second Amendment circles, has been for decades. It's a special pleasure to be with you again, Stephen. I say that both to recognize my co-panelists and also because I think it's probably a good place for us to start in terms of a substantive discussion of what's been going on in the Second Amendment, because the law in this area has changed dramatically. It would be an understatement, really, in the 40 years or more that Stephen has been writing and litigating in this issue. Warren, if you were trying to put together a panel like this even 20 or 30 years ago, and trying to put a law professor on the panel with Dr. Halbrook, it would have been tough because there were just not a lot of scholarly attention was being given to the Second Amendment. Now, there were some exceptions, and one very notable exception is UT's own Sandy Levinson, who in 1987 wrote an article in the Yale Law Journal called The Embarrassing Second Amendment, which helped sort of raise, I think, the sort of scholarly profile, at least, of the right to keep and bear arms. But in defense, maybe, of those who are not paying a lot of attention, one reason for that is that there just wasn't a lot happening in constitutional litigation involving the Second Amendment. There were some mentions of the amendment here and there, and what does the right to keep and bear arms entail? One notable mention, I should plug again, Stephen's work, is in Justice Thomas's opinion in Prince, which is a case you guys either have read or will read in constitutional law, and which Stephen litigated. But for the most part, what you saw across the country really for 2 centuries was every federal court to hear a Second Amendment challenge rejecting it. And really for 2 centuries, there is, that I'm aware of, no federal case anywhere in the country striking down a gun law on Second Amendment grounds. I know of 2 district court cases, they both got overturned on appeal. The reason for that is that judges overwhelmingly thought the Second Amendment applied only to people and arms and activities having some connection to the organized militia. This is all the run-up to Heller. 2008, the Supreme Court in District of Columbia versus Heller, of course, changes that, holds that the Second Amendment protects an individual right to keep and bear arms for certain private purposes, including the possession of a handgun in the home for self-defense. I presume you all have read that case or you're familiar with the background on it. We can answer questions on it in the Q&A. That's a sort of top line takeaway about what Heller held with regard to the Second Amendment. Now, as Warren mentioned, I was one of the attorneys on the losing side of that case. I should also say that I dedicated an entire chapter of my book to defending it as a matter of precedent. So I kind of alienate people on both sides, I guess, of this question. But I think Heller is secure. It's a part of our constitutional law now. It's not going anywhere anytime soon. But, and this is the part of the case that I think often gets underappreciated, Heller also makes it clear that gun regulation is constitutional, at least some forms of it. And I think that's probably obvious. That's how all constitutional rights work, including all your fundamental constitutional rights. They're subject to some forms of regulation. But I emphasize it because sometimes you'll hear in scholarship or case law, and especially in sort of public debates, you'll hear people say things like, I oppose gun regulation because I support the Second Amendment, or vice versa. I hate the Second Amendment because I want more gun regulation. And that's just a false choice. That's a false dichotomy, which Justice Scalia, I think, rightly rejects in Heller. American history, tradition, and law have always recognized both gun rights and gun regulation and how they can coexist. And in the Heller opinion, in fact, and I think the sort of most important passage in it, probably in terms of post-Heller litigation, appears starting on page 626 of the opinion, when Justice Scalia, writing for the majority, says, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on possession by felons, the mentally ill, or prohibiting the carrying of arms in sensitive places such as schools and government buildings, or imposing restrictions on the commercial sale of arms. So I think that's almost exactly what it says. You guys can check it out. Again, 626, 627 of the opinion. The court goes on to say that the Second Amendment does not cover dangerous and unusual weapons, which it equates with those not in common use at the time. We'll talk about really what that means. Court also says that concealed carrying, to the topic of this panel, is not covered by the Second Amendment because, as Justice Scalia notes, the majority of 19th century courts to consider the question held that that bans on concealed carrying were constitutional. For good measure, Justice Scalia also says this is not an exhaustive list. These are just some forms of gun regulation which don't trigger Second Amendment problems. So again, Heller affirms both that there's a fundamental right to keep and bear arms for certain private purposes, and that right, like all constitutional rights, is subject to some forms of regulation. And if I have to make a pitch to you all here, it would be this. That means that all of the important and interesting questions going forward are about what forms of regulation are constitutional and which ones are not. And that is for a constitutional lawyer, and presumably if you all are here, I don't have to sell you on this, that is a fascinating, important, and challenging intellectual task. This is like watching a sort of constitutional right come online. It's like the Second Amendment is basically where the First Amendment was about a century ago, when people like Justices Brandeis and Holmes and scholars like Zechariah Chafee first started breathing life into the right to free speech. And they had to confront questions like, what kinds of doctrinal tests will govern it? What's really this right for? Is it about protecting democracy? Is it about personal safety? I mean, that's what the debate is about the Second Amendment today, or autonomy, or some other kind of theory, right? Doctrinal questions, the theoretical questions, so much still remains to be unresolved. And Stephen, who litigates more than I do, can confirm this. Student notes get cited in briefs in Second Amendment cases and by courts way more often than they do in other areas of constitutional law, like in the First Amendment, where I spend a lot of my time. So y'all are considering where you can make a contribution with your considerable skills. I would suggest that that this is one. Now, that does not mean that the political debate about guns is over, or that the temperature is coming down on that necessarily. If anything, it seems to be going up. The partisan divide on guns is as large, I think, as it has ever been. The last I saw, it was about a 40-point gap between Republicans and Democrats, meaning this is as partisan an issue, probably more so than just about any other hot button political issue you can identify. I don't think that there's a bright line between politics and constitutional law. I don't mean to suggest that. But I do think that there are certain kinds of questions, including some that we'll talk about today, which are lawyers' questions, and they reward the application of sort of the tools of the lawyer's craft. To make that concrete, in the 12 years since Heller, there have been about 1,500 Second Amendment challenges resolved in the lower courts, state and federal. And I'm happy to talk about kind of what the texture of that landscape looks like. Obviously, it's a lot going on. Courts are answering questions like, who gets to exercise this right? Where? With which weapons, subject to what kinds of restrictions? And there's lots of different variations in terms of how those questions get answered. But the dust is actually starting to settle a little bit, and we're starting to get a general sense, I think, of the adjudicative framework, at least as it stands today. Maybe Bruen will change that. In the interest of time and to sort of move us into the discussion of that case, let me just quickly profile what Bruen is about, like what the challenge is, and then say a little bit about what I think are the two biggest issues and how at least one of them I think should be resolved. So the case, again, is New York State Rifle and Pistol Association versus Bruen. It is a challenge to a New York law which requires anybody seeking an unrestricted permit to concealed carry, in other words, publicly carry a weapon concealed, has to show proper cause. Now, this law interacts with a separate New York law, which forbids people to openly carry handguns. And this is just handguns we're talking about here. So if you're going to publicly carry a handgun in the state of New York, you need to get a permit, and the permit will be for concealed carry, not for open carry. The statute does not define what constitutes a proper cause, but New York courts have interpreted it to mean, and here I'm quoting from one of them, that a person must demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. Petitioners in this case were unable to show proper cause, so they could not get an unrestricted permit. They instead got a restricted permit, which effectively makes it impossible for them to legally carry their handguns in populated areas. They can, of course, still have them in their homes. That's what Heller resolved. But they argue this violates the Second Amendment, and in particular, the right to carry a gun outside of one's home. As I see it, there are at least two really big issues potentially in Bruen, one of which I'll call substantive and the other of which I'll call methodological. The substantive issue is that New York's law, this proper cause law, is similar to laws on the books in about 6 or 7 other states. Kind of depends on how you count them, right? And it have to do with like how states differently do licensing for public carry, for concealed carry usually. There are some states in which the licensing agent shall issue a license to a person who is statutorily eligible for it. These are called the shall issue states. So if you are not, for example, a convicted felon or a fugitive from justice or an underage or whatever, then you shall be issued your license in the shall issue states. There are some states that require no permit whatsoever, 21 states, but among the licensing states. And then there are separately states which are called may issue states. New York is an example of this. In addition to being statutorily eligible, you must additionally show something else. Proper cause, good cause, the language changes, but it's usually some sort of like need or reason for having a gun above and beyond kind of what an average person wants. Like you have, you work in a dangerous job, you've got a stalker, some particular reason to be worried for your safety in particular. Just like self-defense law makes you sort of identify a particular threat, the idea here is that you have to identify some form of some need above and beyond the general population. So substantively, Bruen is important because if New York's law is struck down, presumably those other state laws, all of which I think have at this point withstood a constitutional challenge, will presumably be the next laws to be challenged. It's not a long list of states. Again, we're talking about like 6 to 8, depending on how you count it, but they contain within them about 80 million people. So about a quarter of the American population lives in a state with a may issue law. Those could potentially be on the chopping block, depending on how this case goes. That's the substantive thing. The second one, and the one I want to focus on, since this is it's a law student audience, which is great because you guys are familiar with doctrine, and I can talk a little bit about sort of how we come up with constitutional rules. The second one is methodological, because the Bruen court might want to change the sort of overall doctrinal framework that currently applies to the way Second Amendment claims get resolved. And I think this one is in some respects almost even more broadly important because it could apply not just to public carry cases like this one or concealed carry cases like this one, but also to how courts might resolve challenges to the federal law that prohibits people convicted of domestic violence offenses from owning guns or whatever else, what other kind of Second Amendment challenge, right? The current framework that has been endorsed unanimously by every federal court of appeals to have reached the question is often called the two-part framework or the two-part test. The first part of that framework, or the first part of the test, is a threshold determination of whether the law that's being challenged actually in any way impinges on people or arms or activities that are covered by the Second Amendment. And as we learned just a minute ago from that language in Heller, there are some people and some things and some activities that just fall off the Second Amendment map entirely. They're just not covered by the Second Amendment, like people convicted of felonies, people adjudicated mentally ill, dangerous and unusual weapons, fuzzy category, but whatever's in it is not covered by the Second Amendment. They're like the equivalent of like libel and securities fraud for the First Amendment. They involve speech, but they're not protected as speech for purposes of the First Amendment. Lots of cases get resolved at this first step. Hundreds of that, about a quarter of that 1,500 cases I mentioned earlier, have been felons challenging the federal law prohibiting them from having guns. Those cases are almost unanimously losers because courts look to Heller and they say, well, felons are excluded, therefore you don't get to go any farther, right? So that's step one. If the case gets through that first step, then courts proceed to the second part of the framework and apply some form of scrutiny. Now, there's some divergence here. Courts apply different levels of scrutiny, even when they call it the same thing. It might look different in different circuits. But basically, the idea here is the more that a law interferes with the core interest of the Second Amendment, which Heller identifies as self-defense and says is at its apex in the home, the higher the level of scrutiny. So a law that interferes with your ability to have or use a handgun in your home, probably going to be subject to something like strict scrutiny. A law that interferes with your ability to carry an automatic weapon in a populated area, probably going to be subjected to something less, right? That's the sort of overall framework, scrutiny at the second step. In most cases, it ends up looking like something like intermediate scrutiny, which you guys probably encountered already in constitutional law. But there is an alternative test to this two-part framework. And this is where I'll end, is just saying about what this alternative test is and why I don't think it's a good idea. It's associated most with a dissent that then Judge Kavanaugh wrote in a case called Heller 2 when he was still on the DC Circuit. And the test is known as the test of text, history, and tradition. And what it would say is that instead of this sort of two-step framework involving some form of heightened scrutiny, instead, gun laws should be evaluated solely on the basis of text, history, and tradition. And I should say here that in my brief in Bruen, which was filed in support of neither side, I'm not supporting the challengers, I'm not supporting the state of New York, I argue that whatever the court does there, adopting this test would be a mistake. And the reason for that is not that text, history, and tradition are irrelevant. They, of course, matter to the Second Amendment, just as they matter in other areas of constitutional law. The problem is that if we made them the sole measure of constitutionality, I think that we would fail to give judges guidance in hard cases, and actually probably perversely would enable a whole bunch of judicial discretion and sort of intuition-based decision-making. There's nothing in the text of the Second Amendment, there's 27 words, that can tell you whether a certain kind of automatic weapon is an arm for purposes of the Second Amendment, or whether a person convicted of domestic violence crime is among the people who get to exercise the Second Amendment right. There's no amount of staring at the words that are going to answer those questions. History and tradition, hugely important. Stephen's written a lot about this. I've written some about it as well. They're wonderful and important resources, but they don't speak with one voice. We have enormously divergent histories and traditions across the country. New England has had historically much more restrictive laws and still does today with regard to public carry. But on concealed carry, actually, it was the South that led the way in terms of restricting concealed carry. It's thought to be the sort of unmanly thing that an assassin would do. There was enormous divisions between urban and rural areas with regard to gun regulation throughout our history, right? How would a judge average those things together, right? To me, at least, that doesn't make a lot of sense, and it probably opens the door for judges to kind of pick and choose among the histories that they prefer. Texas, I should say, has an enormously rich and interesting history of gun regulation, including in the Reconstruction era, some of the most stringent gun laws in the country. Texas today does not, right? How are we supposed to average that to get the idea of a traditional Texas approach to guns? Happy to talk about some of that more. I think it's also really hard to draw analogies between the late 1700s, when the Second Amendment was ratified, or the mid 1800s, when the 14th Amendment made it applicable to the states, and today, especially when it comes to a fast changing technology like firearms. So some courts, for example, have tried to chart the boundaries of the Second Amendment by looking for the lineal descendants of guns in the founding era and what do they look like today. And I just think that's hard, not just because judges aren't historians, but because guns don't have progeny, right? They don't have family trees. There's no direct line from one to the next. What that means in practice is kind of drawing analogies across time. And I think that opens the door to a whole lot of discretion on the judicial side. Like, what does it mean to even ask, is a modern sporting rifle or an AR-15 or whatever it is, whatever you want to call it, that is, in what way is it like or unlike a musket? Do you compare them, because they can both be held two hands, or because you compare muzzle velocity? Do you compare shots per minute? Do you compare barrel length? Like, those to me all sound like kind of, I don't know, cosmetic features for the most part. Some of them are functional. It doesn't feel to me like a good way to do constitutional law. I think in the end, it's going to end up being less historical analysis and more like, I know it when I see it. These feel similar to me, and therefore that's good enough. And I think that's where all the work is going to happen. that this test of text, history, and tradition is ultimately just going to be a test of judicial analogies, or for that matter, judicial intuition. Sometimes the judge's intuitions will line up with yours. And if you're pro-gun rights and you're anti-regulation, again, that's a false dichotomy. But if you think you're in that position, maybe that'll be good news. Sometimes it's going to be really bad news, because as then Judge Kavanaugh pointed out in his opinion, there is a rich, albeit contested, history of gun regulation in this country. It's very hard to give an overall snapshot here, but I'll just promote a free online resource we have here at Duke called the Repository of Historical Gun Laws. You can look it up while we're talking here. It's a collection of gun laws up until 1934, which is really when the federal government first started getting involved. Freely searchable. There's about 1,500 gun laws in there from all across the country, different areas, different eras, right? There's a lot of stuff out there that might actually end up upholding more gun laws than some form of heightened scrutiny might do. So I'll stop there, turn it over, and just say that, again, as I see it, the really hard questions are not choosing between either the present or the history of rights and regulation, but recognizing that two of these things have always coexisted to some degree, and the hard questions are about sort of moderating the margins between the two. And with that, I'll turn it over to Dr. Halbrook.
Well, Joseph, that was a great introduction to the landscape. I can delve right into some of these issues. It's great to be at UT again. I mean, I wish I was actually there, but I was there a few years ago, and I managed to do 4 FedSoc conferences in 2 days, and I probably must have driven like 800 miles to do that. I don't know. But anyway, thank you all for viewing this. I'm going to pick up where Dr. Blocher left off. The different tests for scrutiny. There's a little bit of a inside explanation for some of this. After the Supreme Court rendered the Heller decision and adopted what we call the common use test for protected firearms, the court said that the kinds of arms that are protected by the Second Amendment are those that are in common use, or those that are typically possessed by law-abiding people for lawful purposes. And so after the District of Columbia lost the case involving its ban on handguns, we filed another case. It came to be known as Heller 2. And we thought, well, this is easy. The Supreme Court just said that guns that are typically possessed by law-abiding people for lawful purposes are protected. And the District of Columbia banned most semi-automatic rifles, which it called by the pejorative term assault weapons. That this should be a winner, that we can challenge that law. And we also challenge the district registration system. So we go to court, and the district court judge ruled against us, and he said, well, the Supreme Court in Heller called the Second Amendment a fundamental right only 2 times, and so that's basically not enough. It's not a fundamental right. We continued to litigate it. The court rendered the McDonald versus Chicago decision a couple of years after Heller and said it was a fundamental right about 12 to 14 times. But when we got up to the DC Circuit appealing the lower court decision, the court said, yeah, these rifles are commonly possessed throughout the United States. In fact, the AR-15 is the most popular rifle. We used ATF manufacturing statistics to show that millions of Americans possess this type of rifle. And but the court was not satisfied with the Supreme Court's test and decided on what it called intermediate scrutiny. Now, if you go back to Heller, Justice Breyer would have assessed gun laws based on an interest balancing test. He said, for example, there was a legislative committee report by the District of Columbia saying that handguns cause murder and it's a big problem, therefore justifies banning them. And on the other hand, the litigants, the plaintiffs in the Heller case, had cited criminological studies showing a lack of a nexus between the handgun ban and public safety. So, but Justice Scalia in the Heller majority opinion rejected this interest balancing test. But what the Heller 2 decision did, the DC Circuit, was to say, well, we're going to go beyond that test, and we're going to do what I think is the equivalent to interest balancing, which came to be known as intermediate scrutiny. You look at the governmental interest. Well, the governmental interest always is there in terms of, yeah, nobody wants violence. We want to fight crime. But is the law the way to do that? In other words, the Constitution protects the right to keep and bear arms, and is that outweighed by arguments about public safety? And the majority in the DC Circuit said, well, okay, it's public safety wins, and the intermediate scrutiny validates the ban on the rifles that were prohibited. Justice Kavanaugh, none of us, of course, had any idea at that point that he would be elevated to the Supreme Court, dissented, and he applied the test of text, history, and tradition. And by the way, we had argued kind of a text, history, and traditional test, except we called it a categorical test. That we argued in the case that the kind of rifles that were protected would be those in common use. And we also argued in the alternative for strict scrutiny. And Justice Kavanaugh in his dissent said that they're just arguing strict scrutiny because more laws would be invalidated under strict scrutiny. Well, that may or may not be the case, but we weren't arguing it for that reason. We were arguing it because that was just a typical level of scrutiny that courts were applying. But at any rate, that's where the text, history, and tradition test really got articulated most blatantly. And now other justices have referred to that, Justice Thomas and others. And we'll see what the Supreme Court does with that. But the nice thing about that test, by the way, I mean, the first component is text. That's pretty darn important. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There is something to like looking at each one of those words very carefully and articulating linguistically how they might apply. It's not just a question of, well, we don't know how everything is going to be decided just from the text, but you might know a lot if you just listen to the words. And in the case of the Bruen case in New York, the right of the people to bear arms shall not be infringed. Heller does an analysis of bear arms, and which is something that one might know by ordinary English to start with. Bearing arms, the court contrasted, of course, with keeping arms. Keeping arms means possession, like keeping in the home, for example. Bearing arms would include carrying arms for purposes of defense or offense, carrying in the pocket, carrying in case of confrontation. Those are different ways that Heller articulated the meaning of bear arms. It rejected the exclusive militia context of bearing arms, which Justice Stevens argued for in his dissent in Heller. It was kind of a half-hearted argument. Justice Stevens said, well, the right to bear arms only applies to bearing arms in the militia, but he did not confront the basic facts that, for example, there's no entitlement to be in a militia to start with. And if you're in a militia, you're in a command society. It's a military institution. You do what you're told. You don't have a right to bear arms at will. If your commanding officer tells you to peel potatoes or do whatever, and you say, well, I'd rather bear arms, and no, that's not any kind of viable argument. So we end up with bearing arms does mean carrying arms. And then we get into, well, where can you carry? There was the text that Joseph mentioned a few minutes ago, that sensitive places, the carrying of firearms in sensitive places like government buildings and schools, that's presumptively valid, a presumptively valid restriction, which by the way implies or seems to imply that, well, in non-sensitive places, one might have a right to bear arms. Now, New York state law basically prohibits possession of a firearm, and it defines a firearm as a pistol or revolver. For possession of an unlicensed firearm that's loaded, the penalty is between 3 and 15 years incarceration, which is incredible. And by the way, in the Bruen case, there was a amicus brief filed by some public defenders in New York City, and they point out the racial discrepancies in New York law, where the percentages of African Americans convicted of firearm offenses, particularly maloprohibited offenses like mere possession of a gun without a license, it's just out the roof, and totally disproportionate to other ethnic groups. So what we end up with is a very draconian law. I originally calculated 42 states had shall issue and 8 states had may issue. I'm tending now to put the numbers at 44 have shall issue and 6 have may issue. They're the usual strict states like California, New Jersey, New York, and so on. So we end up with some pretty draconian penalties, and we have the good or proper cause criteria, which is really very subjective, obviously, in which a public official decides if you have a real need to carry. Under the Second Circuit Kachowski precedent, you don't have a need to carry a firearm if you live in a high crime neighborhood or work in a high crime neighborhood, because you're like everybody else. You only have a proper cause if you're different in some way, if you're distinguished. And that frequently means if you're some kind of celebrity or you're a very wealthy person or you have influence. It also means in New York City, if you paid the right bribes. You can Google New York Firearm Licensing Division and bribery, and you'll find huge scandals that have been prosecuted in the last 4 years of lawyers giving money to the licensing officials in order to get carry permits for their clients, and not just paying money, but providing prostitutes, providing trips to the Caribbean. So there's been some major scandals, and that's one of the problems with the may issue regimes, is that it opens up the door to corruption. If you have a system that applies the same rules to everybody, for example, most states that require a permit to carry concealed, they'll have a training requirement, lack of criminal record requirement, no mental commitments, things like that. But they don't have a fuzzy requirement that you have to show some kind of need that we, the government, determines. And so what we end up with in the city of New York, for example, virtually nobody gets a license to carry. If you go to upstate New York, they're given out much more frequently. So that's the nature of that case. Now, when the petitioners brought the case and presented it to the Supreme Court, the question presented was whether a law basically that bans the carrying of firearms outside the home for self-defense is consistent with the Second Amendment. The Supreme Court changed that nature of the question presented to read whether the applications to carry concealed weapons on the part of these plaintiffs violated the Second Amendment. And as has been mentioned already, New York absolutely bans the open carrying of firearms. There's no license to carry a firearm openly. So the only way that a person can exercise the right to bear arms would be to get a license to carry concealed. Having the license is only an affirmative defense under New York law. If an officer sees a firearm, that's considered contraband on its face, and it's only if you come forward and prove you have the license is it no longer something that can be simply seized without a warrant. So again, looking at text is very important for those reasons. And the problem with the levels of scrutiny is that there's so much subjectivity on the part of courts. Let's look at the case decided last term, New York State Rifle and Pistol Association versus City of New York. The city had a law that you could not well, let me put it this way. New York law provides for a premises permit to have a handgun legally at your home and nowhere else. You have to have a premises permit. So New York City said you cannot take it out of your home other than to go to a shooting range within New York City. You can imagine how many shooting ranges there are in New York City. You couldn't take it to go to a competition up in upstate or across the border into Jersey. You couldn't take it to a second home. So that got litigated, and once the case got to the Supreme Court, the New York City wanted to run and hide and have the case thrown out on standing grounds. So they tweaked that ordinance to say that, well, okay, you can take it if you go by a direct route to these places that the plaintiffs are complaining about, but then you have to come back by a direct route. But the reason that law had been upheld was there was a retired police official who offered an affidavit saying that it would endanger public safety to allow a person with a premises permit to take a gun outside of the city, even though it was unloaded, locked up, and inaccessible, for example, in the car trunk. And he said, why would this be a danger to public safety? Well, it would be because the person might experience road rage and have a shootout and kill people. I mean, a totally fabricated argument. Here's my beeper. I'm going to wind up in a minute. That illustrated the problem with letting courts just say, there's the public safety component. Here's a police officer who said it's dangerous to allow people to exercise their Second Amendment rights, so we're going to clamp down and not let them do it. So the other components of the test that Judge Kavanaugh had articulated were history and tradition. And what's being briefed in the case extensively, what is the history and what is the tradition? On behalf both of petitioners and respondents and the various amici. And they're painting different features. The one argument is that there was a statute of Northampton from 1328 under Edward III that made it illegal basically to go armed, or to ride armed. The other side argues that, well, there's this Sir John Knight case from 1686, which said it only applied if you're going armed in a manner to terrorize other people. Then we've got being briefed the colonial and early American regulations and what did they do or what did they not do. I think if you read the briefs carefully, the petitioners have the better view of these laws. Basically, the only laws that really prohibited the carrying of arms were applied to African Americans. In the southern states, as Joseph mentioned, you could not carry concealed, you could only carry openly. The northern states basically did not restrict carrying peaceably, only if you carried in a way that terrorized other people and they filed a complaint and a court or a judge reasonably determined there was a reasonable threat of injury or breach of the peace, then you could be required to get a surety to keep the peace. So it would be like a peace bond today. So I probably better stop there and let's open it up to some more discussion. And thank you very much.
I see we've already got some questions coming into the Q&A in the chat. Warren, if you'd like, we could turn to those or.
Yeah, we have a number of great questions. So if we turn to them now, it would help us address a bunch of them. I think the first one is from a 3L Henry Humphreys, and it's an important question. He asks how looking at post-enactment, post-Second Amendment enactment tradition is consistent with originalism.
This is a really interesting question, Henry. I actually don't know if this is meant to be a critique of Heller or not, but this is something that Justice Scalia really got pilloried for in the majority opinion, which itself relies on a lot of post-enactment history to define the meaning of the Second Amendment which was ratified in 1791. My own view is that it's fine. I don't think of myself as strictly an originalist. I think history and tradition matter a great deal, but I think there are times when you absolutely should, and Justice Scalia often did look past the point of enactment. Justice Scalia, of course, would do that in due process cases or others that sort of, are constitutional cases being decided by an originalist, but on the basis of like a long-standing regulatory tradition. It's kind of a, I don't know, form of Burkean conservatism. I'm okay with it. There's a doctrinal answer too, which is that when you're assessing the constitutionality of a state or local regulation, that is technically, made applicable. That means the Second Amendment is made applicable to state and local governments by the 14th Amendment, which of course wasn't ratified until the 1860s. So as Justice Alito noted in McDonald, which Stephen mentioned earlier, technically you could argue that the whole historical enterprise should be pulled forward until at least the mid 1800s. But it's a really interesting question. It kind of goes to like what a theory of originalism is all about.
Yeah, I would say it depends on how consistent the post-enactment restrictions are consistent with what existed at the time of the ratification of the Second Amendment. And we had a perfect storm in Heller because, and if you look at the way Heller applies history and tradition, it looks at what came before the English Bill of Rights, for example, the right of Protestants to have arms for their defense and security. And then we move up to the colonial times and when the time of the Second Amendment was debated and then ratified. And if you go beyond that, you have a very consistent view of the amendment. So that, for example, the Second Amendment gets ratified in 1791. St. George Tucker wrote his commentaries, Blackstone Commentaries, his edition of Blackstone Commentaries in 1801, and had the same view of the Second Amendment. There were laws passed on concealed weapons, but they still allowed you to carry. And if you go up into the Reconstruction period, you have a lot of concern about the black codes. For example, after slavery was abolished, the black codes provided that you had to get a license if you were African American to merely possess or to carry a firearm. In fact, the very first law that the McDonald case mentions as intended by the 14th Amendment to be eradicated was Mississippi's law, and it was a discretionary issuance handgun, or rather all firearm discretionary license issuance law. And so you have attempts by Congress to address the disarming of African Americans in the southern states. In 1866, Congress passed the Freedmen's Bureau Act and the Civil Rights Act of 1866, and they were intended to protect the constitutional right to bear arms of all people. And so you have a consistency there with what the Second Amendment was intended to mean and what its scope would be. But if you have a discrepancy, and this has come up in a couple of cases in the last term, I forgot if it was the religion case or the double jeopardy case, but if you have a post-enactment activity, law, treatise, or whatever that's inconsistent with what existed originally, then that's not something you would give any deference to. So I think the test would be, and the further away you get from the original enactment too, it has less weight. So I think you look at whether it's consistent and whether it's closer to the time of ratification as to how much weight to give it.
So before too much time passes, I want to pose to you Jennifer Sirianis's question, which is quite on point for the topic of conversation. She asks, considering in totality Heller's longstanding prohibitions discussion, its emphasis on the acute need for self-defense, and most importantly, the language and the text of the amendment with keep and bear arms not being infringed, how can any public carry licensing regime be justified when it restricts the right of law-abiding citizens seeking to carry commonly used weapons outside the home?
Good question. If you look at the states today, we now have, I think it's 21 states that have so-called constitutional carry, where you don't need to have a permit or a license to carry a gun, either openly or concealed. Most states have concealed weapon licensing requirements, and the majority of states still have open carry is completely legal. And that existed, by the way, it went on up until the 20th century. A state like New Jersey today, which has some of the most draconian laws where licenses to carry are very rarely granted, it had open carry until 1966. And in fact, the state of New York didn't even regulate concealed carry until I think the 1880s. So, it's always a question how far like a state can go with licensing. But one thing that was clear from the antebellum state cases, which were mostly out of the South, was that you have to allow some kind of carry. If you want to ban concealed weapons, you have to allow open carry. If you want to ban open, you would have to allow concealed, which I think is what the petitioners are arguing in the Buing case now. I think the bottom line is not so much whether you have requirements like in the case of a license to carry, like a training requirement. I think the real bottom line is whether you allow the right to be exercised by law-abiding people.
So I'll just add a few more thoughts on that. It is a really, I think, incisive and interesting question. One thing I would add to what Stephen said about legal change, though, it is notable to me anyway. I'm always think it's notable, going back to this theme of how much things have changed since Stephen wrote his first book. Even, I mean, in 1987, only one state had permitless carry. That was Vermont. Now it's 21. At that time, I think 1987, last time I looked at this, only 7 states were shall issue. Again, now it's 20, 21, depending on how you count it. The majority of states in 1987 were may issue. And now, I don't know how they applied at that time. I don't know a whole lot about the standards, but the trend has been, as I see it, very much in the realm of deregulation. Right? Now, it could be that the majority of states in 1987 had unconstitutional laws and we just didn't know it, or the Supreme Court hadn't gotten around to deciding Heller, so it hadn't been declared as such. That's not impossible. Sometimes the court comes around to sort of recognizing a constitutional right late in the day. That happens. I mean, it happens on the 14th Amendment, it happened in the First Amendment for that matter. So that's not necessarily, I think, like, it's not illogical, but it is to me striking, at least, that there was a regulatory system that most states had, at least until the late 1980s. Doesn't mean it was constitutional, but at least that was a common practice. I think that the nub of the question here is really that bear arms has to get you something besides just possession of an arm in your home. It means something other than just keeping a gun in your home. And I think that's not wrong. I think that what it might get you, though, is public carry, some form of public carry. I think this is maybe where Steve and I agree that there should be an outlet of some kind to exercise this right outside the home. And in fact, every state allows some form of public carry. Illinois did not, and its law was, I think, rightly struck down after Heller for total prohibition on public carry. That means bear has to extend outside the home. Where I might disagree with the thrust of the question is that the text is absolute, that the language is absolute. I don't think that's right. I don't think that's how Heller reads it. I mean, Justice Scalia says pretty clearly there's not a right to carry any weapon whatsoever in any manner whatsoever. There's going to be restrictions that are constitutional on the means in which you bear. And again, the hard question is a good cause the kind of restriction that goes too far? And that may depend on the application. It may depend on if it's applied in a discriminatory way, if the standard is too high such that nobody can satisfy it. In that case, then I think you are looking at a real Second Amendment challenge. But the notion that you can't have them, I think is too simple. And I think that's true, even though, and again, the question here pointed us to it, even though Heller emphasizes the fundamental right of self-defense. And the reason that I think that's true is there's slippage sometimes between these concepts. People kind of conflate them, that the Second Amendment is a right to self-defense, or self-defense is the Second Amendment. Like, these are different rights. The Second Amendment right is a right to have on hand and implement to exercise self-defense should that need ever arise. But we shouldn't conflate the two, both practically or doctrinally. Practically, thank goodness, the vast majority of guns will never be used in actions of self-defense, about 1 in 3,500. And the vast majority of self-defense actions don't involve guns, about 1 in 100. So the Venn diagram here is not a huge amount of overlap between those two concepts. Doctrinally, too, and this is where I think if we're going to point to self-defense, we should take its lessons. Self-defense is not something you get to decide to do without any kind of legal restriction, right? There has to be a reason for you to exercise self-defense, and it's governed traditionally by principles like proportionality and necessity. And, if we're going to allow those laws and criminal law to apply to the due process right to self-defense, then I think it's not illogical that they would apply to the Second Amendment as well.
Well, I think this is an important question that Vivek asks, and is certainly related to the practical ability of law-abiding citizens to concealed carry across state lines or public carry across state lines. He asks if litigation is the way forward for concealed carry reciprocity. That is the ability of generally speaking, someone with a permit in one state to, without any sort of permit in a second state, nonetheless travel into that state and retain his practical right to public carry.
You know, that comes up, that's been coming up year after year, that issue. There's been those who advocate a national right to carry that Congress would pass. There's arguments based on the Commerce Clause, the other parts of the Constitution, that if a state gives you a permit to carry, it should be recognized in another state. As a matter of fact, most states accord reciprocity to other states, so that if you have, for example, in Virginia, we recognize Texas permits, which recognizes Utah permits, and so on and so on. So as a practical matter, we're still stuck with basically the same 6 states that don't issue permits generally. There's no reciprocity given to other states. There are also some states that are shall issue. Connecticut is one, but you have to get a permit in Connecticut, even if you're an out-of-state resident, to carry in Connecticut. So it's still available to get a license to carry in Connecticut if you're from another state. They just don't give reciprocity to other states. So New York State doesn't allow you to even basically apply for a license if you're out of state. You cannot carry in New York if you're an out-of-state resident and have no business in New York. There was another Second Circuit case that upheld that part of the New York law maybe 10 or 15 years ago. So I don't know where this is going to go, but a lot of things are just going to depend on what the court does in the Bruen case, and in terms of how it decides the merits, and also how it decides what is going to be the methodology, the standard of review, text history tradition, strict scrutiny, something less than that, enhanced, intermediate, whatever. And it's going to be up to litigants to push forward and to have the usual tug of war and to see where it goes.
Yeah, this is an interesting one, and it's I should say that I tend to think that this is an area, as of many areas, frankly, where there are going to be different answers in different parts of the country, and therefore this is an area where the laboratories of democracy probably should be left to do their work. I should say that's not me being opportunistic. I was arguing this back when Obama was president. I wrote an article called Firearm Localism against the idea of a lot of federal rules. I still believe that. So it's nice for me, I guess, maybe now to be able to espouse federalism. This is, to me, a pretty good argument for federalism. If states want to do what they have done with regard to driver's licenses, then they can, which is enter into a compact. I often, when I've had these debates with people in the past, it's often been, well, we've done it with driver's licenses. There's a federal law that guarantees reciprocity of those. Not so fast, actually. There are restrictions on which states will accept various kinds of driver's license from other states. For example, if there's different discrepancies in age or whatever. But the big difference is that it's a compact. And compacts, by the way, I'll just say for a geeking out constitutional law moment, are totally fascinating, and they should get taught more. But it's basically an agreement that states come to, which then Congress has to bless. That's totally different than Congress mandating that outlier states have to recognize something coming from other states. Now, the harder questions, I think, and Stephen's sort of suggesting this, come from not whether Congress could pass this law under the Commerce Clause. I don't necessarily think it could, but whether it could do so under its full faith and credit power. And my erstwhile colleague, Steve Sachs, who's now at Harvard Law School, wrote a memo with Randy Barnett and Will Bode suggesting that Congress could use its full faith and credit powers. You can probably find that online if you guys are interested in the debate. To me, this would probably have to be a legislative solution, and I don't think it should be one coming from Congress.
So as we're nearing the end of our time here, I want to bring up a question by Seth Smitherman and also tie it into predictions, which I don't think we've quite heard this afternoon. So he asks how true to Heller the lower court's 2-part tests developed over the course of the past decade have been, which leads me to ask both how you think this Bruen case will come out and how the court will rule on proper tests, proper doctrines going forward.
It's a really huge question, Seth, and a totally fair one. But as I said earlier, with 1,500 cases, it's tough to generalize. There's going to be outliers in all directions. As you could probably guess based on my defense of it earlier, I think the two-part framework actually is, in the run of cases, working pretty well. And I don't think that's just because it's true to Heller. I think it's just, it is sort of archetypally just how we do constitutional law. Like when you guys took your, or if you're taking right now constitutional law, I guess the one else will be watching this later, you guys may be in con law right now, you'll recognize, if you kind of see this, there's always a threshold question of, is this a constitutional challenge at all, right? Is this the kind of speech that's protected by the First Amendment? Is this exercise protected by the free exercise clause? Is this an equal protection challenge at all? It's always a threshold challenge of that. That's Washington v. Davis and those kinds of cases, right? So it would be weird if the Second Amendment didn't also have a threshold kind of a test to establish whether you're in the Second Amendment at all, right? And Heller gives us some guidance on that. That's the felons and the mentally ill sort of exclusions, right? So that's part one. So then the question is just, well, is it weird or is it odd for courts to do scrutiny? And I think no. I think that's how we do most constitutional rights. The tiers of scrutiny are not inevitable. They're not deeply baked into constitutional law. I mean, like, they don't go all the way back to the founding, but for most of the past century, that is how we've done a lot of constitutional law. And by the way, we don't do strict scrutiny across the board for all fundamental rights. Sometimes hear people say this, well, Second Amendment's a fundamental right, therefore it's got to be strict scrutiny across the board. Again, not so fast. Strict scrutiny is only parts of the First, Fifth, and 14th Amendments, only parts. Lots of speech is not subject to strict scrutiny, right? So I think some form of tiers of scrutiny is totally appropriate here. I think it's more transparent and more open than the text, history, and tradition approach, which, although it will result in a lot of historical citations, is ultimately going to be governed, as I was arguing earlier, I think kind of by intuition. Having said all that, I don't disagree with what Stephen said earlier, that sometimes there are courts, and maybe the last New York case was one, that are not putting enough bite into that test. I don't disagree with that. I think that's entirely right. And I think that if that's the case, the proper remedy is error correction. It's not to redo the whole thing that's been applying over, again, 1,500 cases now for 12 years. You don't just alter all that and throw it out and apply a new test, which doesn't really apply anywhere else in constitutional law, except arguably maybe the Seventh Amendment. And my colleague Daryl Miller has a great article on that, but I'm going off too long, and I'll stop, pass back over to Stephen.
So everybody wants to know how this case is going to come out, right? And so I'm not going to predict. Remember, que sera, sera, whatever will be, from The Man Who Knew Too Much. That's an old movie. But let me point out a couple of things. You hear things in oral arguments that are really cool, that you get the formal opinion and you have no idea what goes on in the courtroom. But when Heller was being argued, I think it must have been in the context of maybe standards of scrutiny or whatever. But Chief Justice Roberts asked the question, I think maybe to counsel for the district, Walter Dellinger, who was, I argued against in the Prince case, who is a very fine colleague. And he asked Walter, well, didn't we courts make up this standard of scrutiny stuff? Aren't these tests that excuse me, that are judicially created? And he sort of asked, like, why don't we just ask, is, like the text says, is the right being infringed? And then speaking of which, when you look at the text, another question came out from Justice Kennedy during the Heller argument. And everybody figured Kennedy was the swing vote, like he was in so many cases. And so neither side really knew where he was going to be headed. So when he opens his mouth and everybody gets on the edge of their seats, we've got the seats, the council seats filled with everybody who had an interest in the case, pro and con. And Justice Kennedy said, asking Walter, weren't the settlers of this country people who needed to have firearms to protect themselves from criminals and hostile Indians and grizzly bears? And I always thought the grizzly bear thing was cool because there were no grizzly bears east of the Mississippi. But I know Walter's heart sunk, and counsel for petitioner's heart was elated when he asked that question, because it showed, and Kennedy's thought, it was an individual right. But you never know when they ask these questions where they're going to go. The first case I argued was a case under the National Firearms Act, and Justice White was on the court then, and he asked the government lawyer a question, kind of ridiculing the government lawyer's argument. And then he voted against me. So You never know what they're going to do, but I think everybody seems to be depicting the court as maybe 6-3 or maybe 5-4 on this issue. Let me say something about Amy Coney Barrett. There's been a lot of attention paid, like in her confirmation hearings, about her Cantor versus Barr dissent, where she argued that only nonviolent felons, not felons that have no connection to violence, should be disarmed. And that she used, I think, pretty much text, history, and tradition to argue that. But there's another case she decided for on the Seventh Circuit, and she wrote the majority opinion. It was 3-0, and it was called United States versus Watson. It was a Fourth Amendment case. And she said this: citizens should be able to exercise the constitutional right to carry a gun without having the police stop them when they do so. Well, when you combine a quote like that with the opinion, that the very extensive dissent that she wrote in the Cantor case, I think there's reason for optimism that she would vote to invalidate the New York law. And when you look at the other justices, Justice Alito and Gorsuch and Thomas dissented in the New York City case. You look at Justice Thomas dissents in a number of other cases, including Kerry cases, the Peruta case from California, for example, dissents from denial of cert. If you want to read the tea leaves, I think, or if you want to do some betting, you might best bet on the petitioners, but you never know. There's no way to weasel out of the case like the city did in the prior case. New York State's not going to just change its law to issue permits. So they do suggest in their brief that, well, if you're going to rule against us, don't do that. Just remand the case for further fact finding. I don't know where that would get you. We all know what the interpretation definitively is by the Second Circuit of New York law based on New York State decisions. You don't get the permit just by being a law-abiding person with training and whatever. We have to decide whether you're going to be entitled to exercise the right to bear arms.
That's quite a quote from Justice Barrett. I hadn't heard that one. Before we go, Professor Blocher, can we, would you hazard a prediction?
I am 0-1 in Second Amendment litigation, having been in the room when Justice Kennedy asked that question about bears. So I'll defer to the actual Supreme Court litigator on the panel as to the possible outcomes here. The only thing I would add is that I could envision a split that's more complicated than 6-3 or 5-4, where you could get a sort of 3-2-4 or something with perhaps Roberts and Alito moving together, or Roberts, Alito, and Kavanaugh moving together. It's hard for me to say, but hold my breath till June. It's going to be interesting one way or the other.
Sure will. Well, thank you all. Thank you both for joining us. Thank you guests. Thank you attendees, present and future. We'll see you again next week for an event about affirmative action. Thank you so much, guests.
Thank you for
having me. Warren.